Hey everyone, Harry here to talk about the Second Circuit's denial of Trump's motion to stay his second removal motion in the New York criminal case. All right, first, this looks like much ado about nothing, at this point, a kind of a silly motion. This was originally brought to try to remove the case as one among his efforts, Trump's efforts to keep the sentencing from going forward. And now Juan Merchan has held the sentencing will not go forward. And so it feels as if this whole thing should be moot. This is the one, it's hard to keep track of all his various efforts, but this is the one where he said for a second time, I want this case removed to federal court. The district court said no. It actually first said you did it in a procedurally infirm way, and then it said no in a way I'll explain in a moment. And now the latest is the Second Circuit has said, hey, we're not going to do this. We're not going to give an emergency administrative stay, which is what he was thinking of, because the court has now adjourned the sentencing. So it's not going to be happening. No need for emergency, and all the arguments he's saying about irreparable harm if he's sentenced go away. Right? So it seems to follow, and what's the big deal? And the whole thing is dead. Here's the problem. They have technically made a ruling that not to grant a stay, and Trump was seeking, when he filed in the Second Circuit, a stay of the whole proceeding, even though Merchan had already put the sentencing over, for reasons basically having to do with an argument that under the immunity case, the whole thing should go away. Now, his argument here is flawed 5 ways till Sunday, and all of those should be very good reasons that the Supreme Court of the United States does nothing with this case. And I would predict that the Supreme Court of the United States does nothing with this case. Let me just explain a few of the reasons. First, technically, hang in there, but this is persnickety law stuff that matters. What the district court really decided is, I'm not going to let you file a removal motion because you haven't stated anything and it's procedurally infirm. So although Trump tries to make it seem in the Second Circuit that he denied the removal, actually the motion that's in front of the Second Circuit that's now been affirmed is refusal even to take it. Second, when something is pending, a criminal proceeding in state court, there's a general principle for the federal court not getting, in the muck of it. Third, as the Second Circuit has said, what's the big deal? There's no irreparable harm or injury to think about. Therefore, they don't say it's moot, but they say his motion for an emergency administrative stay, which is, basically a way of saying do a stay that's not even exactly on the merits, is denied. So what do we care? The Second Circuit has ruled, and it is conceivable that Trump now go to the Supreme Court on some very far-reaching principle that basically is, this case should never have been brought. There's no jurisdiction for this case because of immunity. The whole thing is flawed. Supreme Court of the United States, please boot this. And while such a question would not be cleanly presented, indeed, it wouldn't really be presented at all. And that's the reason you just can't imagine what the actual question presented should be. Did the district court err in holding that the second removal petition wasn't properly presented? What kind of business is it of the Supreme Court even thinking about such a picayune case-specific question as that? But it's at least within the realm of conceivability, and we have to think about that realm when we're thinking about the U.S. Supreme Court, that the case could be framed by Trump when presented to them into something a lot broader that would be a frontal attack on the New York case and conviction itself. That wouldn't be, immunity necessarily, because remember, the immunity case has to do with official acts, and the acts here, as the district court previously held when he tried to remove it, they are totally, this is before he's president, so he's just a candidate, and it's paying hush money to a porn star to keep things from coming out. It's completely seems unofficial action. But is there some way to basically position and reconfigure this so it is cert bait, at least to those who are most sympathetic to Trump and hostile about this whole, all the criminal prosecutions against him, to maybe grab at? Okay, I want to repeat where I started. This is a basic nothing decision by the Second Circuit that gives no basis for the Supreme Court to review, and I think that's what'll happen. But I wanted to explain it just so it's a little bit, in our consciousness, and until the Supreme Court denies cert on it. That would be after Trump brings a petition for cert and it's answered, and we're probably talking first Monday in October, which is when the Supreme Court kind of issues all its denials for things that have aggregated over the summer. But we live in a crazy enough world, at least where the U.S. Supreme Court is involved, that I thought it was worthwhile taking 5 minutes of your time to explain. But this is a nothing decision that doesn't present really any federal question to grab onto, and I think this will be the end of the road, especially since the sentencing has already been put off. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.